So I have an important update in the current lawsuits against the ATF and their pistol brace rule, which includes that nationwide injunction right now against the rule. The ATF is doubling down on their new argument that all these lawsuits are invalid because they avoid paying taxes. So let's talk about what is now going on in this case and what are the implications going forward. Also, I want to thank one of the main supporters of the channel, which is 1st Phorm. Many of you have been noticing that I've lost some weight over the last year. I lost about 50+ pounds. And that was kind of a process that I was going on. And now I am working with 1st Phorm to maintain that and to also offer you guys some help along your journey if you're interested. 1st Phorm has a lot of amazing supplements. I love their protein. I love a lot of their other products. But one of the cool things that they're also doing now and offering to you guys for free for 30 days is their app. The app has a lot of cool features. It helps you track your food, your macros. It has some training tips. So check them out using the links down below. And again, that's 30 days free of their app if you're coming to 1st Phorm for the first time and signing up. As I mentioned in the intro, we have some important updates in the ATF pistol brace cases. As we discussed last time, the ATF is now trying to get out of these cases. They're trying to get the lower court to throw all these brace cases out by claiming that if these lawsuits are allowed to proceed forward, it would allow the plaintiffs to engage in tax evasion. That's right. The ATF is now claiming that all these lawsuits are invalid because they would prevent you from paying a tax which is required under the NFA. The ATF now claims that they cannot be sued over their brace rule since it would lead to the evasion of paying a required tax under the NFA. This is a similar argument to what the ATF made in their Texas suppressor freedom case. The ATF is now scrambling to protect their new rule on braces, and they're using tax evasion and those arguments to claim that the plaintiffs cannot bring these lawsuits. But the plaintiffs, FBC, and others in this lawsuit and other lawsuits have now completely destroyed those arguments. And along the way, the ATF also made a huge mistake and a huge admission when it comes to the NFA and taxes. You may recall that the ATF recently decided to roll the dice and appeal all the pistol brace cases up to the 5th Circuit Court of Appeals. Those appeals include the Mock v. Garland FBC case, the Brito v. Garland case, which also dealt with the nationwide injunction against the brace rule. And then you also have some other lawsuits, the SAF case, the NAGR case, and the GOA brace lawsuits as well. Although the ATF has already lost once in the 5th Circuit Court of Appeals in the Mock case, the ATF has decided that the lesser of evils for them is to appeal all these cases up to the 5th Circuit and hope that something positive happens for them. With all those cases that were appealed up to the 5th Circuit, the 5th Circuit Court of Appeals has now consolidated all those cases and will soon hear oral arguments in those lawsuits. But despite those appeals, which were requested by the ATF, the agency is still trying to get the lower court to issue a summary judgment in their favor by now arguing that the tangential aspect of the NFA's tax means that all these lawsuits were invalid and should have never been brought and should be thrown out. What this argument amounts to is the ATF claiming that they cannot ever really be sued as long as they require a tax stamp under the NFA. But in their recent brief and reply, the ATF made a huge mistake, overlooked some critical aspects and facts, and also made a huge admission. This challenge to the pistol brace rule is not a challenge to the process of registering an SBR or having to pay that tax specifically. Instead, this is an APA challenge to the actual legitimacy of how the pistol brace rule was made. It's a claim that the APA was violated. And then also there were Second Amendment challenges brought as well in this lawsuit. The NFA tax component is only peripheral to the challenge in this case. But the ATF is now trying to hang their hat completely on the taxing component to have these lawsuits thrown out. Now, if you're not aware, recently in the Brito v. ATF case, Judge Matthew Kaczmarek issued a preliminary injunction which blocked the pistol brace rule in its entirety while that case proceeded forward. That decision by Judge Kaczmarek springboarded off of the recent decision by Judge Reed O'Connor in a different case, which was the Mock v. Garland pistol brace case. However, in the Brito case, the judge there, Judge Kaczmarek, kind of went the extra mile and granted a request for an injunction against the entire brace rule, and that was a nationwide injunction. You may recall that the other pistol brace case, Mock, the judge there did issue an injunction, but the injunction only protected FBC members, those members of FBC, and then other organizations kind of sprungboard off of that, got protections like GOA and NAGR, but also that FBC lawsuit, Mock, gave protection for maximum defense in some of their customers as well. So it was a little bit more limited. The Brito case is one of the main ones that gave nationwide relief. And now with the Mock loss and the Brito loss, the question was, what would the ATF do? Well, the ATF decided to roll the dice and appeal both of those cases and a bunch of other cases up to the Fifth Circuit Court of Appeals, hoping that a new type of relief would be granted to them even though they had lost prior on appeals. This is definitely a risky strategy, like I mentioned, because they've already lost in the Fifth Circuit. They've already lost in this mock case. They've already lost in APA aspects, specifically on a likelihood of success on the merits. So all the Fifth Circuit will be reviewing is if the judge there, Judge O'Connor, and some of these other judges looked at the 3 remaining factors and if they appropriately applied them to issue these injunctions. But again, this is not a good setup for the ATF. Now, despite those appeals, the ATF is still asking for a motion for summary judgment in the lower courts in front of Judge O'Connor in the mock lawsuit. And their primary argument for why these cases need to be thrown out and why they should be granted their motion for summary judgment is taxes. They make an argument that this lawsuit is barred from being brought or reviewed by any court because the plaintiffs aim to obstruct the collection of the NFA's required taxes. They claim that under the Tax Anti-Injunction Act, Americans cannot sue the ATF to stop the pre-enforcement of this rule. Instead, the ATF argues that under the AIA, there is a requirement that individuals, that these taxpayers have to go through. There is a process that they have to go through. They have to register their braces. They have to register those brace pistols as SBRs, seek a refund from the Attorney General if they think that is improper, and only if the Attorney General's office then denies those refunds can then the individual person sue to recover those taxes that were paid. And they say that is the express and specific process that individuals have to go through and that these specific lawsuits are improper. Of course, this is an absurd argument to make, but it's similar to what the ATF did try to make in the Texas Press for Freedom lawsuit. Also, when you look at that Texas law, in many ways, the law directly challenges the NFA's process and the tax requirements. But these pistol brace challenges do not actually do that. Instead, these are challenges built on the APA and on Second Amendment arguments, which argue that the ATF never even had the authority to create this new rule. Any impact on stopping the payment of an NFA tax component is really just a side issue that the ATF is now trying to bring in to get these cases thrown out. In their brief, FPC argues that this suit contests the validity of the final rule under the APA. The relief requested does not target the NFA's transfer tax. This case has, at most, a tangential and incidental impact on the government's taxing power, so the AIA has no application here. The ATF responded to those arguments recently by doubling down on their tax evasion claims by stating that, here by contrast, the NFA's registration requirement is not several steps removed from the statute's tax. Rather, it is a critical part of the NFA's integrated taxing scheme as it is necessary to enable ATF to assess and collect the statute's tax. Now, this argument, in my opinion, was a huge mistake and an error of whoever wrote this. The ATF is taking the position now that the NFA's language is so integrally tied with the taxing requirement that this issue is really all involved with taxes, and at the core, the NFA's requirements are really a tax requirement. What is interesting about this argument is in other NFA challenges, the government tries to remove the statutory requirements from the paying of a tax. They try to remove it from the tax element to avoid the concept that the NFA is a tax on a fundamental right and a violation of the Second Amendment. But in this case, they're almost conceding finally that exactly what we've been saying this whole time, that the NFA is an improper and invalid tax on a fundamental right, which ultimately brings up even more concerning conflicts with the whole constitutional violations and questions about that, about the NFA violating the Second Amendment because it's impermissible tax on a right. And here, the ATF got so wrapped up in making their tax arguments that they're almost bringing in a new issue and an issue that we've been wanting to be brought for a very long time. Now, whether or not that's going to be picked up on and litigated in this case is going to be interesting, but the ATF is throwing a bunch of Hail Marys. They're throwing taxes out there. And I think in some ways they kind of bound themselves up in an argument that they probably didn't really want to make. Personally, I think they are not going to win on these AIA arguments, but we'll have to wait and see how this plays out. But I think Judge O'Connor is going to rule against them once again. So if anything else develops, if anything else changes in this case, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.